This is Justin Caplin. One of my priorities is to prevent and fight child abuse. So today I want to share an article written by Judge Michael Leavitt. He's one of our 2 juvenile court judges here in Washington County, Utah. This is an article he wrote a few years ago. It's called Protecting Against Child Abuse Through Legal Process. And in this article, Judge Leavitt explains child protective orders and contrasts those with some perhaps better tools for protecting children, but that are rarely used. And so he kind of highlights some differences, some weaknesses of the child protective order, some limitations that we're aware of. And so I wanted to read through that. I appreciate his write-up because some of the points that he makes about child protective orders and their misuse, and not intentional misuse, but just filing them without understanding the legal standard, can get people frustrated and result in a denial of an order that perhaps something's needed, even if it's not the child protective order itself. So let's go ahead and get started. I'm just going to read through it. I'll provide a little bit of commentary on it, but mostly just read through it. It's a great article. Protecting kids against child abuse is an issue that seems to have universal support. How we do so is sometimes up for debate. Juvenile courts are the primary arena where folks try to figure it out. Too often, when seeking the court's assistance, petitioners use the wrong tool to obtain that protection. When that happens, one of 2 unfortunate outcomes can result. First, even if the facts do not meet the requirements for the order being sought, the court may be tempted to grant some relief for the sake of protecting a child, even if it is an error. The results can be an unconstitutional imposition on parental rights, unnecessary involvement of children in court, and improper judicial activism. Second, and far more likely, the judge will not grant the requested relief. In that case, petitioners may not fully understand why and may conclude that the court is not an adequate forum for protecting children, and a child who needs protection may not get it. Filing the right petition matters. If done correctly, children are protected and parents' rights properly respected. Attorneys, particularly those in the domestic arena, and victims' advocates need to be able to advise petitioners on the type of relief they seek and how they should best obtain it. So his first section is going to be on child protective orders. Most often, individuals seek to protect children from abuse through a child protective order. Any interested person may petition the court for a child protective order on behalf of a child who is being abused or is in imminent danger of being abused, so long as they make a referral to the Division of Child and Family Services first. Now I'll read this next line and then point something out. Child protective orders are limited in scope and are intended to provide immediate and urgent relief. They are reserved solely for children who are being physically or sexually abused or are in imminent danger of such. Now, I want to point out that this article was written and published in 2019. Since then, there's been a change to the law that does provide some different relief. So for a child protective order against a parent, a step-parent, a guardian, or a custodian, that's still the same standard. And the sexual or physical abuse, that's still the same standard regardless. But they have carved out, or added, I should say, that child protective orders can be filed against someone who has caused abuse, who has abused a child, if that person is not a parent, step-parent, guardian, or custodian. And so that's something new in the law from a couple of years ago, that came out after his article was written. So there's that little distinction there, but it still is limited to the physical or sexual abuse. So it continues. Physical abuse is non-accidental harm or threatened harm that results in physical injury or damage to a child. Sexual abuse includes sexual intercourse, sodomy, incest, or molestation by an adult towards a child or between 2 children with certain limitations, or engaging in conduct that would constitute a criminal sexual offense as defined by statute. It expires after only 150 days unless the court finds good cause to extend it. So that's another change in the law. It was 150 days. Now, against a parent, step-parent, guardian, or custodian, it still is that 150 days unless the court finds good cause to extend it. But a child protective order against someone who's not parent, step-parent, guardian, custodian, Again, it can be based on past abuse, not current is being abused, and it doesn't expire at 150 days. That can be in place until the child is 18. He continues, too often the facts stated in a petition supporting a child protective order do not meet the limited definitions of the statute. And I agree. A lot of times they get filed related to other concerns, some legitimate concerns, but that don't meet those definitions of physical or sexual abuse, or that is based on something from the past and not something that presently is an issue. For example, actual abuse in these circumstances must be currently occurring or the threat imminent, as opposed to past or speculative future abuse, like I was just saying. The language of the statute refers to the child being abused or in imminent danger of being abused. Again, now that's only if it's against a parent, step-parent, guardian, or custodian. This is distinct from language under the Juvenile Court Act, where the court may adjudicate a child as an abused child, which means a child who has been subject to abuse, with no particular reference to timing. As such, if a child protective order is the only petition before the court, a previously abused child may not receive proper protection unless the allegations show current abuse or an imminent danger of it. And oftentimes that's a reason why protective orders are denied. Second, the petition must be directed toward a respondent, an individual to be enjoined from committing the abuse, having contact with the child, or visiting certain places where a child may be present. At times, a petition may name a parent as the respondent, but the actual abuse is being committed by someone else, the respondent's partner, another family member, or neighbor, only where the parent has the ability and responsibility to protect the child from the abuse should that parent be the respondent in a petition. Otherwise, the respondent should be the person committing the abuse, even if that person is another child. The statute does not prohibit multiple child protective orders to protect a single child or set of children, but the allegations as to each respondent must meet the limitations in the statute. So I've had child protective order cases that have been filed against a parent alleging that, that a half sibling or a step sibling has been committing abuse, and so that is something that can be filed. But it does make for a somewhat awkward thing unless you can prove, if they're wanting limitations on that parent, like they have to prove that that parent is engaged in some sort of, failure to protect sort of issue. Further facts alleged in a petition for a child protective order often show that a child is being mistreated, but that the circumstances more likely meet the definition of neglect or emotional abuse. Neither is covered under the child protective order statute, though each may assuredly lead to harm. Though it may be tempting for the court to issue a child protective order in such circumstances to avoid possible or even actual harm, it would be error to do so unless the facts also meet the definitions of physical or sexual abuse. I really appreciate him pointing this out, because you do from time to time get judges that don't follow the law and that enter protective orders when they shouldn't, or that enter different orders when the legal requirements for that aren't really met. So I've heard of some, I haven't been involved in any like this, but I've heard of some that have been granted based on excessive use of alcohol or drugs or something like that. But that's not physical or sexual abuse. And so that's not a reason why a protective order should be granted. So I appreciate that he kind of calls out that there are some judges that make that mistake and enter that in error. These limitations in the narrow scope of the child protective order are important to consider because these orders are initiated and granted ex parte. So that means that the judge reviews the allegations, reviews the petition, and assuming that those are true, if it meets the legal definition, the legal standard for a protective order, for a child protective order, then grants that ex parte, meaning without allowing the other side an opportunity to even know that it's going on. And so if it's granted ex parte, then the respondent ends up being served with an order that restricts and limits their rights and things, because the court, that's the process that's in place to do that, to provide some immediate protection. And then they have a hearing and a process for whether that will continue in place or not. He continues, the statute requires the court to review the petition and determine, based only on one side of the story, so the petitioner's side of the story, whether the child is being abused or is in imminent danger of abuse. If granted ex parte, the court is infringing on a parent's constitutional rights without due process, and it could be up to 20 days before that respondent parent gets an opportunity to address the court at all. Very frustrating, and this is when I represent respondents, especially if they're not abusing the child, they may have their parent time revoked for a couple of weeks, 2-3 weeks, and it's very frustrating. It can be difficult for the child. I was just in court on an unrelated case. This is in district court just this week, and a case that was on before us had a couple of child protective orders with the same parties, and the guardian ad litem was asserting that the dad's parent time was currently suspended based on the ex parte child protective order, and the guardian ad litem who represents the children says, I don't think the abuse is happening, and this is bad for his clients, the children, to not have that contact with his dad. Again, the guardian ad litem thought that mom was making it up, and that there was a history in that case stuff. I'm not commenting on that particular case, other than I just saw that, and that's what the child's attorney was saying. Back on track. So if granted ex parte, the court is infringing on a parent's constitutional rights without due process, and it could be up to 20 days before that respondent parent gets an opportunity to address the court at all. This presents a significant potential for abuse of the judicial process in denying a parent their rights. As such, judges are rightfully particular about ensuring that the grounds for issuing a child protective order remain within the legal bounds mandated by the legislature. While a child protective order allows for immediate relief, it covers a relatively limited number of circumstances where it is necessary to protect a child who is in the midst of physical or sexual abuse. The expedited and ex parte process provides an appropriate protection. It is not appropriate in other situations, however, where a child may still need protection. Other options should be explored. Next section is on petitions for adult protective orders. Those are filed in district court, not in juvenile court. Often, individuals will seek to have children protected through the use of an adult protective order issued through a district court. Any cohabitant who has been subject to abuse or domestic violence, or to whom there is a substantial likelihood of abuse or domestic violence, may seek a protective order. And that comes straight from the code. A child likely will not be a petitioner in this instance because he or she cannot generally meet the definition of a cohabitant for purposes of this statute. So there's an exception in there that the cohabitant does not include the relationship between a natural parent, adoptive parent, or step parent to a minor. And so they generally can't be the petitioner. A person who does qualify, however, may include in the petition other parties to be protected by the petition. And we see this a lot in adult protective orders. When somebody's going through a divorce or something, they'll file the protective order. They'll ask for the children to be protected as well. As such, those children may be protected by the adult protective order. In order for children to receive protection in these instances, it must appear from the petition that the petitioner first meets the legal definition of a cohabitant who has been subject to abuse or domestic violence. Too often, a petition for an adult protective order focuses on protecting the children without first meeting this requirement. If the petition fails to do so, entering an adult protective order solely for the protection of the children is improper. Only where a petitioner first establishes their own statutory right to protection may they include other persons to be protected, including their children. And we do see this from time to time where a parent is only seeking protection for their child and doesn't include what they might need for themselves, even though they're filing it as an adult protective order. They're not alleging the details that are needed in there to show that there's been abuse or domestic violence. And honestly, it's a broad definition. There's so many things that constitute abuse or domestic violence for purposes of an adult protective order. Most people who are filing one to try to protect the kids probably have at least something that they could include in there to actually grant that. Now, I'll also comment that this is often misused as a weapon and not as a tool to actually provide protection, but as a weapon to try to gain an upper hand, temporary upper hand in a divorce action. And because the definitions are so broad, then it's easy to go ahead and qualify for one, even if, in my opinion, it's not really needed, that there's not really protection needed. That's a topic for another day. Okay, so the next section he talks about is where he puts the emphasis, and it's something that's rarely used by private parties. So these are petitions for abuse, neglect, or dependency in the juvenile court. Less frequently, private parties file petitions with the juvenile court seeking an adjudication of a child as abused, neglected, or dependent under Utah Code section. I should have looked this up. The sections have changed since he did this. It's now chapter 80. I think it's still 304. I think it's still a 304 petition, but I'll have to post or something the actual citation. Anyway, under Utah Code, Juvenile Court Code, which are most often filed by DCFS. I would say almost exclusively they're filed by DCFS. When private parties do file a 304 petition, they are generally relatives seeking guardianship of a child and are usually petitioned as such, meaning petitioned as the guardianship, with allegations of abuse or neglect being at times tangential to the request for guardianship, if included at all. A party need not wait for DCFS to take action in these cases once they are filed. Any interested person may file a 304 petition seeking to have the juvenile court adjudicate a child as abused, neglected, or dependent. Similar to a child protective order, the petitioner must first make a referral to DCFS, but once the referral is made, the interested party may file a petition without regard to the status of the DCFS investigation. And just like the child protective order, you have to make a referral to DCFS first, then you can go ahead and file the petition without waiting to see what DCFS does. Once a petition is filed, even prior to adjudication, the juvenile court may make an order providing for temporary custody of the minor. This may result in placement of a child in the temporary custody of that interested party prior to adjudication of the petition. In addition, the court may enter a temporary restraining order directing a party to refrain from harassing, abusing, annoying, visiting, or interfering with any party or the subject minor. So there are some broad temporary restraining orders that the court can grant. There still has to be grounds for that, but the juvenile court can do those things. If the court ultimately adjudicates the child as abused, neglected, or dependent, it has relatively broad authority to make any number of orders, including guardianship, parent time, treatment requirements of parents, or other orders for the best interest of the minor and as required for the protection for the public, which may include further prohibitions on contact with the parents if they are a danger to the children. These orders are not restricted to 150 days, but may exist as long as the court retains jurisdiction over the child and in cases where permanent guardianship is ordered beyond that. Too often, facts presented in a petition for a child protective order more properly qualify for relief under a 304 petition. True, the process to obtain a child protective order is simpler, and there are state-approved forms to assist the petitioner where there are no such forms, where no such forms exist for 304 petitions. Use of a child protective order makes removal of a child from the custody of an abusive parent easier. 304 petitions require more time and notice to parties and more familiarity with the legal system, but they also allow the court to consider more facts and circumstances and give the court more flexibility in fashioning a remedy that ensures a child's safety and protects the rights of a parent. A child protective order and, where appropriate, protection of a child through an adult protective order are band-aids designed to resolve an immediate problem. Adjudication of a 304 petition is a long-term treatment plan designed to eliminate a child's exposure to abuse, neglect, or dependency. Each has its purpose. In one instance, the need for immediate action outweighs the need to provide notice and an opportunity to be heard, but the scope of redress through the court is limited. In another, the child's needs do not outweigh a parent's right to notice, but the court may more broadly address a family's concerns. Recognizing the appropriateness of each is important to ensure the proper balance between protecting parents' rights and protecting kids from danger. Practitioners and advocates are wise to understand this distinction. So that's the end of his article. It is a good, even for practicing attorneys like myself that deal with child protective orders and abuse claims and custody fights and guardianships and that sort of thing. We rarely file 304 petitions in the juvenile court, the abuse, neglect, and dependency petitions. And this is kind of a good reminder that that is a tool that's there that should be used and that can be used when a child protective, when protection is needed, but a child protective order may not be the right direction. And So thank you to Judge Leavitt for his article. And if you've got any questions, then let me know.